Okay, so we are at our last panel. Had a lot of information shared, overwhelming amount, all amazing. Lots of activity in the Q&A, so keep it up. Paula, I have your slides, so I can tell, you'll just tell me when you want them on.
Did you get
And
the latest slides that would have come through just a few
15
minutes ago?
ago.
Yeah,
no,
maybe
okay.
about 15 minutes ago, I sent them to Nina, but not essential. The only thing we switched out is my face.
It's
I will
fine.
forward them right now.
I see them. I have it. Hold on. I'm gonna open it and hopefully that should work for me to share it.
Okay.
Okay, just
And what
hold on.
time, just so we keep ourselves honest here, and I know everybody's been on.
You are done at 2:55, but
Okay.
but I hate to say this, if the questions come, like we'll we'll go a little bit past 2:55 because I'm just gonna say a quick thank you to everybody. So okay, so let me figure out how to share my screen.
Here we go.
We'll try to be
Yes.
time conscious. I know you all have been at it for a long time today.
Okay, let's see if this works. This should. Okay, hold on. So I need to enable editing. Oh dear, did I do that? Oh, sorry about this. Hold
No,
on.
just do
Yep, there. And okay, and do start from the beginning, slideshow from the beginning. Okay, I should be
all
on.
right.
Okay.
Okay, perfect. Thank you, Debbie, and Nina, and Michelle, and hello, everybody. Happy Thursday. I'm Paula Knudsen Burke from the Reporters Committee for Freedom of the Press, and I'm joined today with my panelists, Heather Murray and Gunita Singh. And once we get to the next slide that has our pictures on, I'll let them introduce themselves. But I work here in Pennsylvania, and I get to do all kinds of interesting transparency work. And one of my dear colleagues in that effort is Heather. So I'll turn it over to her.
Nice to see you all today. I'm with the Cornell Law School First Amendment Clinic. I run what's called our local journalism project, which takes on a lot of similar matters to what the Reporters Committee handles. And indeed, in Pennsylvania, we're oftentimes partnering with Paula on transparency work.
And my other dear colleague, Gunita Singh, from the Reporters Committee.
That's right. Thanks, Paula. I'm so excited to be here. I've been at Reporters Committee for close to 7 years, and I focus exclusively on public records litigation.
So we're going to walk through, here's the snapshot of the day. It'll go Paula, Heather, Gunita, but we will answer questions as they come in through the chat, so please don't be shy. For those of you who don't know the Reporters Committee, our next slide just briefly covers that. Our organization has been around for more than 50 years, and we are headquartered in Washington, D.C., but we have lawyers on the ground in Pennsylvania, Indiana, Oklahoma, Colorado, and Tennessee in no particular order. And we, as Gunita said, do a lot of work on public records, open courts, and we do trainings like this. And Heather, your next slide is about the clinic.
Yeah, and like I said before, we handle both transparency work on behalf of journalists, non-transparency work as well. So if you have operational needs, we'll handle those. Like you have a freelancer contract that you need reviewed, for example. And then we also have a free speech side of our docket where we represent citizens who have free speech related issues.
Okay, so we wanted to start out by just making sure everyone on the call had access to our open government guide. If you go to rcfp.org, that's our website, and you can get to the open government guide. It's one of our really tremendous resources. It provides information about open government, including body camera in all 50 states and Washington, D.C. So if you have questions and you're a reporter today who's calling in from Maryland, for instance, you can go on that feature and find out more about various things. And then at the end, we'll cover We also have a hotline that's staffed by attorneys in our DC office. If you have more questions, and we have a FOIA wiki that's linked out from our website that gives you all the information and more you could want to know about FOIA. And Gunita is one of our experts in that law, and she does a lot of litigation. So keep that handy as a bookmark, and we'll start out on Pennsylvania. We're going to touch on Vermont as a point of comparison. Heather has litigated in Vermont, and every state has a different body camera law. So we're going to start out talking about Pennsylvania and look at the history of that. So we still see a lot of confusion about Act 22, the body camera law here in Pennsylvania, even from agencies. Oftentimes a requester will put in a request for body camera footage or motor vehicle recording, and the agency will say, okay, that's a right to know law request. It is not a right to know law request. So if you take anything away from today's presentation, please know that body camera and motor vehicle recording is not the right to know law. It's entirely different. This law, Act 22 of 2017, replaced what had been the law. Up until that point, requests for footage went through the right to know law, and a Supreme Court of Pennsylvania case that is known as the Grove, Grove case, came down and said, yeah, the requesters might be able to get motor vehicle recording, and the investigative exemption might not always apply. In the wake of the Grove decision by the Pennsylvania Supreme Court, the legislature then passed Act 22 of 2017, carving out body camera and motor vehicle recording footage from the right to know law. It is now an entirely different process. However, there is some similarity, some overlap, and I think that's what results in the confusion. The way the law is written, it talks about, and we'll get there in a moment, submitting your request to the open records officer. And that sounds a lot like what we would do with a right to know law request, but it is a different process. And this is the mechanism for obtaining audio or video recordings made by a law enforcement agency. And that definition includes the Office of Attorney General, a district attorney's office, or an agency that employs a law enforcement officer, which is then further defined. So this is a pretty new law. As far as we know, there have been no legislative oversight hearings exploring the efficacy or non-efficacy of this law. So it's still pretty new, and if anybody has seen a study by a legislative agency or an academic institution, we'd love to see it. But we don't, as far as I know, there are none out there. So pretty new law. We'll go to the next slide. The difference between Act 22 and the right to know law is very stark. You must submit in a specific time frame. It's 60 days from the time of the incident. So if I, get my toe run over today by a municipal police car, and it's probably my fault that I stepped out into the street, but my nosy neighbor wants to see that footage, nosy neighbor would have to do it within 60 days of the incident. And there's the OOR, the Office of Open Records, which is the adjudicatory body for everything under the right to know law, has an explanatory page that includes the form that you would use, but they don't hear these appeals. That form also says, why do you want the records? Very different than the right to know law, which explicitly says the purpose or identity of the requester, it cannot be something that's taken into account. Here, in my hypothetical, nosy neighbor would say, I'm the nosy neighbor. I saw my neighbor get run over. I want to know what happened. That form must be hand delivered to the police station or sent via certified mail with proof of service. And again, the way the language is written, it talks about the agency's open records officer. But we've heard from journalists throughout the state that when they go to hand deliver this request, there is some confusion about who should get this request. So just be aware, it's a totally different form. It's a totally different time frame. And the explanation piece, I think, kind of, we could analogize it to FOIA with the public interest prong, where you might say, I'm a journalist, I'm writing in the public interest, here's why I want to know. It's that kind of thing if you're doing it as a journalist. The agency then has 30 days to respond. They can assess reasonable fees. In a recent example from Lancaster County, we saw Manheim Township Police Department was going to assess a newspaper almost $6,000, I think, to provide footage. In the end, that they reconsidered and provided it to the requesting news agency for free. We do not have any case law on what reasonable means. So your guess is as good as mine. We can make an analogous argument to say under the right to know law, if a document is provided and it's digital, then there are very few instances in which a fee may be assessed. And under the right to know law, the time that is taken to make the document can't be then passed on to the requester. But there is no such language in Act 22, so we don't really have any clarity on what that means. Then if there's a denial, the appeal goes to the Court of Common Pleas, not to the Office of Open Records. So this is a very different scheme than what would happen if you asked for a different kind of record. So anything in the chat about questions on that? Okay.
Not a question, but I'll just note that that's putting much more of a burden on journalists to have to do that as opposed to going through the OOR. And hand delivering or sending via certified mail, that's unusual.
Yes, when this bill was making its way toward the governor, there was opposition from the News Media Association lobbyists saying, wait a minute, this is a very different and pretty onerous process. We've got a great process with the OOR. It's free, it's pretty quick. You could email, fax, hand deliver the request, but the decision here was to go a different route. So this is more difficult. It's a more difficult process. Next slide, Debbie. All right, so as I mentioned, the Office of Open Records has guidance on requesting police records, I think primarily because they often have misdirected requests coming to them. So they develop this page that gives you a lot of handy information, but they do not adjudicate Act 22 requests. So you can find information on the OOR page, but don't file your appeal with them. They will reject that. So there are only a handful of cases in Pennsylvania litigating this issue, primarily because, as Heather points out, it's a lot harder to file this kind of case than just going to the OOR. So one of the first ones we know of was my colleague Terry Muchler, who was unable to make it here today. We litigated this case. And it involved a request by Harubi Miko, a staff writer for LNP at the time, wanted body camera footage of Black Lives Matter demonstrations that happened on the public street right outside of the city the city police department. And the Lancaster City Police denied that. We took an appeal to the Lancaster County Court of Common Pleas. There, the district attorney's office joined in the litigation. It was the city as the original respondent, and then the district attorney's office joined in. And their argument was they couldn't turn over the video because there were some folks in there who got arrested, and the argument was the Criminal History Records Information Act, CRIA, prohibited release of the records. In the end, after some productive conversations, including a couple visits to the police department to watch how the body camera redaction software worked. They were able to do a heavy blur to blur out those persons who might have had criminal cases and then release the rest of the footage. So it was about a dozen hours of footage that was released there. And one of the big companies that many police departments use is Axon, and that was the software company involved in that case. So no court decision out of that one, bringing us to our next in time, which would be Thompson. This was in the Cumberland County Court of Common Pleas. Charlie Thompson from Penn Live filed an Act 22 request, actually with a number of departments. There were several different departments that responded to this fatal shooting. And all of them said no. In the end, we again were able to negotiate with the district attorney's office, and they allowed Charlie to watch the video and take notes on it. And then we moved on from that case. So no court decision there, 2 settlements in a row. And now that brings us to, hopefully, NEFIN. And I'm going to turn that over to Gunita to talk about.
Thanks, Paula. So in this case, we're representing LNP, Lancaster Online, and one of its reporters, Dan NEFIN, who's been with the paper for quite some time. And this involves an Act 22 request for body-worn camera and dash cam footage of officers using substantial force in arresting some juveniles who were riding their bikes in potentially unsafe manners. They were riding their bikes in such a way that was blocking traffic, and at least one bystander actually filmed the interaction. So we have somewhat of a window into what transpired. And it turns out that one of the arresting officers used his knee and placed it in the back of one of the juveniles. So the juvenile is kind of on their stomach, and then the officer has his knee in the back of this youth. And obviously this raised substantial concern in the community. There were town hall meetings in Lancaster. There were renewed conversations about both the importance and the urgency of police accountability, given that, young people were involved in this interaction and the force seemed, quite significant. The district attorney determined that the officers used an adequate, appropriate amount of force. So there's no, ongoing investigation or prosecution of those officers, just a ton of unanswered questions. Did the officers give verbal warnings first? Did the officers use less severe force at the onset? The one bystander video that we have doesn't answer those questions. The only thing that can answer those questions, which speaks to the public interest prong of the analysis that Paula was talking about, is getting access for ourselves to the body-worn camera and dash cam footage. So we filed a lawsuit in the Court of Common Pleas in Lancaster County. And we are actually filing a brief later this week in support of our position that the denial is inappropriate, because the denial that the city of Lancaster is based on is the fact that juveniles are present in the video. And there's a law in Pennsylvania called the Juvenile Act, which essentially says that any information in court records pertaining to juveniles has to be kept confidential. But our perspective here is that if you redact or blur the faces or the identifying clothes of these juveniles, which of course you should, juveniles have strong privacy interests, then these records do not pertain to juveniles at all. They only pertain to law enforcement. And of course, there is a extremely strong basis for understanding the operations, activities, on-duty conduct of law enforcement officers. That's why this law exists in the first place. So stay tuned. Maybe by this time next year, we'll have a resolution of this case.
Thanks, Gunita. And one of the reasons why these cases haven't been litigated much is because there's a balancing test. So Act 22 has put into place a balancing test that a judge must conduct to say, on one hand, there's a public interest, and on the other hand, there's a law enforcement interest, whether that's investigative or some other thing. And the judge is required to do this balancing test and say, yes, you get the footage, no, you don't. And that's why I think both law enforcement and requesters are a little bit reluctant to see how that shakes out. We think a lot of these cases that we've been litigating that have particularly occurred outside on public streets where there have been people filming it as bystanders, kind of remove some of the argument that there's an investigative feature that might be impaired. It happened on a public street. And even if there is something that might be implicated, there's the redaction feature Gunita was talking about. So Dan, I see your question that are there requirements for police, et cetera, to use body cams? What if they say, sorry, it wasn't on? Are there penalties? So great question. This is kind of scattershot across the Commonwealth. Some departments use them, some departments don't. There is no requirement to use them. And I think most municipalities or other places who are using them, it's really the policy of that agency. So if it's a township agency and they have their own body-worn camera policy, most of them say, if you're on duty, you turn the camera on at such and such a point and it should stay on. I haven't seen a ton of cases on that point, but it, from a public policy perspective, taxpayer money is being expended for this equipment. And a lot of the arguments for body camera footage and equipment was, well, it's for officer protection and safety so that we know what happened if there's a challenge, and also for public transparency so the public understands what's happening. But that obviously doesn't work if the camera isn't turned on. So it's something I don't think Act 22 really addresses. And yeah, go ahead, Heather.
Oh, and I was just going to chime in. I think with jurisdictions across the country, before George Floyd was killed, there wasn't much in place, but after that spurred changes across the country. So in Vermont, for example, within months of that happening, they had passed a law requiring the state police to all wear body cams. So I think it is a more recent development that some jurisdictions are now requiring it and having policies like Paula was mentioning.
Thank you. And Gunita, do you want to say what you just put in the chat?
Oh, sure. I think somebody had asked a question about how does Act 22 apply when obtaining footage from a local law enforcement department that might have an agreement with a federal entity like ICE, for example, or the Marshal Service. There is some case law on this issue, and it can apply to any public record statute in Pennsylvania or beyond, that a private contract, like a memorandum of understanding or some memorandum of agreement, that's not going to preempt a legislatively enacted statute like a public records law that has strict requirements about what needs to be disclosed and what can potentially be withheld.
Okay, so yeah, so stay tuned about NEFN. And then moving on,
I see a question in the chat on NEFN too. Somebody's asking, you can't show videos of juveniles to protect them at the same time that the police were abusing them. So to the city attorney, how would that protect juveniles while your police were abusing them? Blurring the kids should solve the problem.
That, Dan, great point there. If it, our argument is the blurring technology exists. If the concern is the kids, question mark, is the concern the kids? Then we can blur. And we know that blurring is appropriate because our Pennsylvania Commonwealth Court and our Supreme Court have said in right to know law cases involving video, different kinds of video, that blurring is an appropriate capability. So, Gunita, did you want to say something else there?
No, just we feel, 99% of state public records laws have what's called a duty of segregability. So if only portions of a given government record are exempt, the agency can't just wholesale withhold the entire thing. They have to redact the portions they contend are exempt and then timely produce the remainder. And in an age where government business is conducted with new technology, for example, AV technology, audiovisual technology, that duty to redact, it extends to video. And that kind of technology is just ubiquitous this day and age.
Thank you. Yeah, so stay tuned to see how that case, and we have oral argument in Lancaster in early November in the Neefan case. This case is new. We have not received a response yet from the Pennsylvania State Police, but it is a coalition of Next Star television stations who we represent, and they are attempting to get body camera footage from a fatal shooting of a a person in Pennsylvania. He was in Ohio, had an encounter with an Ohio trooper. That body camera footage of the encounter between these two individuals was released by Ohio authorities. The individual then took the Ohio police car, sped into Pennsylvania. That footage was released. So the body camera footage was released. The Ohio motor vehicle recording footage released all the way into Pennsylvania, crossing the border. You can hear and see what the man in the Ohio law enforcement vehicle is saying and what he's seeing in the road. Pennsylvania State Police then engages in a pursuit once he crosses over into Beaver County, Pennsylvania. They intercept him with a traffic control device, hit him. You can see the car rolling in the video from the Ohio footage. A pedestrian on the other side of the street, on the other side of the highway, is taking footage. There's aerial footage, lots of footage from other places, including the Ohio state government. But when the television station asked the Pennsylvania State Police for the footage from this incident, they denied, citing the investigative exemption, despite the fact that the person is dead and the Beaver County District Attorney has cleared the troopers of any wrongdoing. So it'll be interesting to see how state police respond. This is pending in the Dauphin County Court of Common Pleas. And I'm going to turn it. So that's kind of where we are in Pennsylvania. Not a ton of cases for us to talk about, but by way of comparison, we're going to hand it off to Heather because she's gotten some good decisions in Vermont, and it gives us a window into how other states are handling these kinds of challenges and what we may see eventually here in Pennsylvania once one of these cases makes its way through the court system.
Thanks, Paula. Vermont doesn't have an Act 22 like law, thankfully. So in Vermont, things are handled through the Public Records Act there, which is the counterpart to the RTKL. And my clinic has handled the two most recent that we're aware of body cam cases in Vermont, both successfully, both on behalf of one of our longtime clients, Vermont Journalism Trust, which operates VT Digger, which I'm sure some of you are aware of the great work that investigative outlet does. First case I'm going to talk about, which we ended up settling and didn't end up getting a decision on, was a very high-profile case where there was a high-speed chase and a 19-year-old rookie part-time officer, Jessica Ebbinghausen, was killed during this high-speed chase. Hundreds of police officers from around the Northeast came to her funeral. My client, immediately after this happened, sought access to the body cam footage, and Rutland refused to release it. And of course, our client was seeking access to the footage, not only because it was this high-profile incident, but because there were questions about whether the police should have gone on a high-speed chase to begin with, because this was a small-time burglary suspect that they were engaging in this high-speed chase with. Should a rookie officer that was still in training even have been involved in a high-speed chase? And so those were questions that our client was seeking answers to on behalf of the public. And put in the request and then got an initial response citing sort of a plethora of exemptions to withhold access to the records, a couple of which made no sense at all, and the third of which you could get together an argument, but not in this instance. And I'll talk through those in case it comes up eventually in Pennsylvania. One of the exemptions they cited is the pending litigation exemption in Vermont, saying that that exemption shields records to which an agency is a party during the pendency of the litigation. It's quite concerning that they're citing this exemption because one, the city of Rutland wasn't a party to any litigation, and two, that exemption, which many states have, typically only applies in the civil context and not the criminal context. And you could see why, because if it applied in the criminal context and the state is a party to criminal cases, then you could be essentially withholding all criminal records during the pendency of litigation. So they dropped that exemption pretty early on in the suit, but did initially cite it. They also cited the ethics exemption in Vermont, which allows you to withhold records if it would cause the custodian, by releasing them, to violate standards of ethics or conduct for any state-regulated profession. That's also a very odd exemption to be citing in this case. The ethics exemption, in fact, in other states, including Arizona, there's good case law saying that you can't cite the ethics exemption when what you're really doing is handing over public records. The contents of public records are generally exempt from sort of the ethical restrictions on prosecutors. And so that one they also dropped relatively quickly, but it did resurface again in our second case. So it seems to be one that some people in Vermont think is worth considering citing. The third one that came up at the beginning of the case is fair trial, and then later on they cited additional exemptions. But then our case ended up settling out of court. Many jurisdictions have mandatory settlement requirements early on in the case, and that happened in this one. So before we completed briefing, we went to settlement, and we luckily had a very good mediator who convinced the other side, I think, that they didn't have a strong argument here. And so we were able to get access to those records. Let's move on to the second case. Second one, Vermont Journalism Trust v. DPS. This case was another high-profile one that we took on last year, involving getting access to the Bodycam footage during the initial arrest of Ava Vakos, who was the top prosecuting attorney in Addison County. She showed up to a crime scene allegedly drunk, and then refused to take a field sobriety test. Her license to practice law was temporarily suspended, and yet the state police refused to release records of body cam records of that incident. And I'll say this case, unlike the other one that settled very quickly, this one went through 2 rounds of briefing, because initially they filed a motion to dismiss, and so it didn't get resolved at that stage. And then we had to go through another round of briefing. So it took well over a year to get access to the records in this case. The 2 key exemptions they were citing in this one were fair trial, which I mentioned briefly earlier, and interference exemption. And those 2 come up fairly frequently. I'd say interference much more frequently in the law enforcement context. And we got a really good decision in this case, both at the motion to dismiss stage, where the court took a look at the case law and a look more generally at the law enforcement exemption in Vermont. There's an exception within the exemption that says if records are what's termed their initial arrest records, then they fall outside the exemption and you have to release them. What's difficult about that is there's no clear definition of what constitutes initial arrest. So when does it start? When does it end, right? And so at the motion to dismiss stage, court didn't decide that particular issue, but said clearly some of these records are initial arrest records because you're getting her right at the scene. But because they hadn't produced what's called a Vaughan index, an index of the records at that time, the court said, I don't even know what all the records are. I can't rule on whether all of them fall within initial arrest, but at least some of these records must be released. So then we went to summary judgment stage. Judge ordered that the index be released. And so then we were fighting over, at that stage, state police were still saying we can withhold, despite the fact that the judge already ruled that at least some of these records are initial arrest records and you're going to have to produce them, was still arguing that all of the records fell within fair trial or interference exemptions. But they had really no basis and provided no evidence for why it should fall within those exemptions. You can't just say, for fair trial, you really need to demonstrate that not just that there could be bias with potential jurors, but you really need to demonstrate more than that. And there's very little case law finding that the fair trial exemption in a particular case, in fact, allows you to withhold the records. And they provided no evidence in this case. A jury hadn't even been sat at that point. And so the court sort of rejected fair trial out of hand. And then the interference exemption, really their entire argument was wrapped up in fair trial. And so they were adding on interference, but didn't have a real argument with respect to that either. And so the court rejected interference as well, and noted, really relying on federal case law, because there's barely any case law in Vermont on the interference exemption, relying on federal case law saying, if an agency is trying to withhold with respect to the interference exemption, you need to really demonstrate that either there's going to be witness tampering if the records are released, or something else that really interferes with the investigation. And here, these are records that Ava Vagos already had. And so there was no real claim you could make that the interference exemption applied. And so the court released all the records, and then in a footnote, I think to the court's relief, said, because I'm, deciding this way, I don't need to decide today what the scope of the initial arrest exception is, and when the arrest starts and when that ends. We will leave that to another day. So.
Thank you, Heather. So those kinds of arguments that we see coming up in Vermont and some of the other states, we anticipate that we'll be seeing them in Pennsylvania as our relatively new law starts to gain traction. I'm going to put in the chat one of the more recent kind of overviews I've seen throughout Pennsylvania about which cities have used Act 22 and released them. And it's a survey from Philadelphia on across the state. But we are seeing at the state level, and I think this goes to one of the questions in the chat, what if there's a mix of departments there? State, federal, local authorities, who do you put the request in with? I think put the request in with everybody and then start narrowing it down.
Mhm.
And a lot of times, we saw this recently in one case I was involved with, where the law enforcement agency came back and said, listen, do you really want everything from that entire day? Or do you want from, the time officers responded to the incident? So I think it's worth it to put requests into every agency. In that Penn Live case I was talking about, Charlie Thompson put requests into every agency. It can also be instructive to see how they answer, because you may end up with an answer from one department that is different than another one. Out in Colorado, our colleague Rachel, who is the Colorado Local Legal Initiative attorney, had a good ruling just 2 months ago. We also had a good ruling out of Tennessee. So I think, again, if there's state, local, and federal authorities there, sometimes the state law is going to be better than maybe pursuing it through federal authorities, because not all federal police, and authorities wear the cameras, and it could be a more challenging situation, at least in some of our states, even if our laws are more difficult in terms of the balancing test and the way a request has to be submitted. We have timelines. So Gunita, in FOIA world, I mean, things can drag on for how long?
Years.
Mhm.
Yeah. So that's one benefit of if there's a state or local law enforcement agency there that has the footage, asking all of them. And remember, in Pennsylvania, it's got to be hand delivered or certified mail. So if you have questions about any state, FOIA, body camera footage, the intersection of the two, please feel free to jot down our legal hotline. It's 24/7. If there is an urgent situation where a journalist is facing an imminent threat of arrest or has been arrested, it'll ring through our answering service, and you'll get to a live lawyer. And this is our legal hotline is how we do a lot of our intake. So if it gets into our system and we think it's interesting, then we'll be talking to clinics like Heather's and other First Amendment clinics throughout the country who do this kind of litigation. So it's body camera footage throughout the country is challenging, but we are seeing wins, and we'd love to see a win for transparency here in the Commonwealth. So what questions do we have here?
So I'm curious for
Yeah.
this body cam camera footage laws, like how long ago was the first law put in place? And what was that first state's law? I'm just curious, since we don't have the depth of court cases yet.
I mean, this really started gaining traction within the past 10 years, Heather.
Yeah.
And I don't remember what the first state was. We had a map at one point on the reporter's that was showing which states were picking up the laws. Many states now have adopted some version of the law, but this is quite recent.
Yeah, and I think litigating these cases is really important, because as you've seen from the handful of cases we've talked about today, there's very little basis when it comes to at least initial arrest records to withhold them, and yet agencies can get away with withholding for years. Like, for example, the Uvalde school shooting in Texas. Many of you may have seen that just last month, those records were released 3 years after the fact. And they were withholding for similar reasons to what came up in my cases. They were citing potential jury bias and concerns about witness recollection and recollection and things like that. But there's really no basis if you're just saying potentially a jury could be biased, because if that were in fact the test, then everything could be withheld, right? So
And there's so much already out there, you know,
exactly.
that could bias a jury to begin with. So yes.
And I just
Exactly.
put in the chat our map. I will say, I think there are some states that have picked up body cam statutes since the last time this map was updated, but it at least gives you an idea of where these statutes are.
The most up-to-date information on body-worn camera access throughout the country is going to be in the Open Government Guide. Admittedly, the map that Paula sent is a little bit outdated, so just go to the Open Government Guide and everything is up to date.
All right. Well, this is great. Thank you so very, very much. We will be sending out to the attendees the chat so that we'll make sure that it's on a resource document to share with everybody. So I want to